of all before the law and prevents arbitrariness. The task of the court is to ensure there is a fair balance by applying the law when disputes arise either between the state and its citizens, or between citizens themselves, or between state organs or agencies. Neither a state organ or its officers or individual is above the reach of the law, as the Constitution in Article 2, Sub-Article 1 declares. The power of the court to adjudicate disputes, according to the law, is a delegation by the people pursuant to Article 159, which states that judicial authority is derived from the people and vests in and shall be exercised by courts and tribunals established by under the Constitution. The power is exercised subject only to the Constitution and the law, and is not subject to the control or direction of any person or authority by Article 60. The following excerpt from the South African Constitutional Court in the case of Secretary of Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in public sector, including organs of state versus Zuma and others, sums up the position of court orders in a constitutional democracy. The court held, orders and decisions issued by a court bind all persons to whom and organs of state to which they apply, and no person or organ of the state may interfere in any manner with the function of the courts. It follows from this that disobedience towards court orders or decisions risks rendering our courts impotent and judicial authority a mere mockery. The effectiveness of court orders or decisions is substantially determined by assurance that they will be enforced by all and sundry, including organs of state. In doing so, courts are not only giving effect to the rights of the successful litigant, but also, and more importantly, by acting as guardians of the Constitution, asserting their authority in public interest. End of quote. In the civil application, Dr. Fred Matiang'i, the Cabinet Secretary, Minister of Interior and Coordination of National Government versus Miguna and 4 others, the Court of Appeal, affirming the power to punish for contempt, held as follows. When courts issue orders, they do so not as suggestions or pleas to the persons at whom they are directed. Court orders issued ex cathedra are compulsive, peremptory, and expressly binding. It is not for any party, be he high or low, weak or mighty, and quite regardless of his status or standing in the society, to decide whether or not to obey, to choose which to obey and which to ignore, or to negotiate the manner of his compliance. This court, as must all courts, will deal firmly and decisively with any party who deigns to disobey court orders, and will do so only to preserve its own authority and the dignity, but most to ensure and demonstrate that the constitutional edicts of equality under the law and the upholding of the rule of law are not mere platitudes but present realities. End of quote. The court entered a finding of guilty. This court entered a finding of guilty on the 9th of September 2004 after all efforts afforded to the contemptor to punish the contempt were ignored. This was to ensure its authority and dignity, which it is exercised on behalf of the public, does not get annihilated, leading to a situation of impunity and anarchy. The Supreme Court, in Githiga and 5 others versus Geriko Tea Factory Company Limited, acknowledged that courts have inherent power to punish for contempt, to vindicate their authority, besides pinpointing the source of authority of Kenyan courts to punish for contempt after declaration of unconstitutionality of the Contempt of Act 2016. The court stated, and I quote, courts possess the inherent power to enforce compliance with their lawful orders through sanctions imposed through contempt of court. We note that the Contempt of Court Act, having been declared unconstitutional in Kenya, Human Rights Commission versus Attorney General and another, 2018 EKLR, on November 9, 2018, the instructive provision remains Section 5, Subsection 1 of the Judicial Act, which grants the High Court and the Court of Appeal the power to punish for contempt. It provides the High Court and the Court of Appeal shall have the same power to punish for contempt of court as for the time being possessed by the High Court of Justice in England, and that power shall be extended to upholding the authority and the dignity of subordinate courts. End of quote. Today, this court is required to pass sentence for contempt of court. The principles to be considered in determining an effective sentence in a contempt of court matter were considered by the South African Constitutional Court in Jacob Zuma case, where the court discussed the coercive versus punitive order and explained the difference between the two approaches as follows. There is a distinction between coercive and punitive orders, which differences are marked and important. A coercive order gives the respondent the opportunity to avoid imprisonment by complying with the original order and desisting from the offensive conduct. Such an order is made primarily to ensure the effectiveness of the original order by bringing about compliance. A final characteristic is that it only incidentally vindicates the authority of the court that has been disobeyed. Conversely, the following are the characteristics of a punitive order. A sentence of imprisonment cannot be avoided by any action on the part of the respondent to comply with the original order. The sentence is unsuspended. It is related both to the seriousness of the default and the contumacy of the respondent, and the order is influenced by the need to assert the authority and the dignity of the court to set an example to others. End of quote. The court then went ahead and found that the conduct of the contemptor, Mr. Zuma, had made it undesirable to benefit from coercive order, reasoning as follows. A coercive order would be both futile and inappropriate in these circumstances. Coercive committal, through a suspended sentence, uses threat of imprisonment to compel compliance. Yet, it is incontrovertible that Mr. Zuma has no intention of attending the commission, having repeatedly reiterated that he would rather be committed to imprisonment than cooperate with the commission or comply with the order of this court. Accordingly, a suspended sentence, being a coercive order, would yield nothing. End of quote. The contemptor in this case was accorded every opportunity to punch the contempt, to the extent that attending a workshop in Mombasa was more important than obeying a court summons intended to seek an explanation on the whereabouts of the second to the petitioners, last seen on the 19th of August 2024, the date of alleged abduction. Nevertheless, I took note that on the last date, the contemptor attempted to bring in his deputy to explain the position with regard to the summons. The deliberate defiance of court orders brings impunity, particularly when it is done by those entrusted with public power, as it is inconsistent with the purposes and the objects of the Constitution. In passing this sentence, I am conscious that it is directed to the highest ranked police officer in this country. He is still in office. That might pose a challenge in the enforced seniority is highly regarded. That, however, cannot deter me from pursuing and standing firm in the defense of the aspirations of Kenyan people who desired at the time of enacting this constitution to have a country that is governed by adherence to the rule of law. Part of the oath of office that I took as a judge states as follows: I will at all times and to the best of my knowledge and ability protect, administer, and defend this constitution with a view to upholding the dignity and the respect for the judiciary and the judicial system of Kenya. End of quote. The constitution of this country is supreme, and Article 2.1 reiterates that by stating that it binds all persons and all state organs. No man or state organ or authority is above the Constitution. The Constitution command through this court is that I uphold the rule of law by protecting the integrity of the judicial system. The significance of this sentence today is to vindicate the cherished principle of the rule of law in our constitutional democracy by restoring the dignity and the authority of this court in public interest. Borrowing from the South African Constitutional Division, the contemptor shall serve sentence as follows. The contemptor, Mr. Gilbert Masengeli, is sentenced to 6 months imprisonment. Mr. Masengeli is ordered to submit himself to the Commissioner General of Kenya Prisons to ensure that he is to be committed to a prison facility to commence serving sentence of the imprisonment imposed. In the event that he does not submit himself to the Commissioner General of Prison Service as ordered, the Cabinet Secretary for the National Interior must take all steps that are necessary and permissible in law to ensure Mr. Gilbert Masengeli is committed to prison to commence serving the sentence imposed on him. The court, nevertheless, finds it desirable to impose this sentence as a coercive order as opposed to a punitive order. In that regard, Mr. Masengeli may avoid serving this sentence, and therefore, in that regard, the court shall suspend this sentence for 7 days only. The acting Inspector General of Police can redeem himself and comply by availing himself before this court in person to answer to the issues he has been avoiding in default. The sentence shall automatically become effective.
From the Law Society of Kenya.
Yes, just
from the Law Society of Kenya, we thank the court for the
Law Society takes precedence, Mr.
for the Law Society, my lord. We just want to say thank you.
Okay, just a minute, Mr. I will hear. Yes, Mr. Your name?
Maura Kabata. From the Law Society of Kenya, my lord, we thank you for the bold ruling. We also are cognizant of the second, third, and fourth petitioners, Mr. Bob Njagi, Jamil Longton, and Aslam Longton. They are still permanently prejudiced. There is a duty, my Lord, on the first defendant the first respondent to uphold, administer, and defend the Constitution and any abrogation of that duty transfers an obligation to invoke the supremacy of the people of Kenya my Lord, when we come to the issue of stay, it is an equitable remedy to those who come to the court.
Has it been made?
It has not been made. I do not think I will have an opportunity to address you on that because my senior, President Harvey. From the Law Society of Kenya, we are still very concerned about the whereabouts of the second, third, and fourth petitioner. And even as we embrace your ruling, my Lord, we pray that the court makes a focus in the application as well as the petition, so as to get to the bottom on the safety, the whereabouts, and the personal presentation of the petitioners before the court. My Lord, I want to rest there and thank the court profusely for the ruling. Thank you so much, my Lord. May I proceed?
Yes, go ahead.
My Lord, prior to the reading of the sentence, Mr. Bitter and I tried to address the court on a procedural issue but were not given that opportunity. In the issue at hand, my Lord, was the issue of mitigation prior to sentencing. My Lord, now that that procedural step has been denied the first respondent, we're now applying our application be heard this afternoon or latest by tomorrow, bearing in mind that you have suspended the sentence for 7 days. Or latest, Monday. Today or latest Monday. My Lord, any date after 7 days for our application for hearing would be flying in the face of Article 25. And you'll have condemned the Inspector General of Police to a 6-month sentence without his application having been heard, without him having extinguished his rights that are guaranteed under the Constitution. And therefore, it is our humble prayer that the directions given on our application be for hearing inter partes either this afternoon or on Monday. That's all.
Hello, we're still on our feet. Yes, with the permission of my learned senior, Miller, permit me just to make a small adjustment. It would make sense if the applicant sought leave, and if leave was granted, to amend Prayer 3 in that application. Prayer 3 sought to suspend the sentence pending the hearing of the application. We now need to amend it to align it with the ruling that has been given by the Honorable Court. So we seek leave, my Lord, to that effect. Number 2, which is a housekeeping issue, it would make sense, my Lord, that as we set the application, today's application for hearing, we hear it together with the petitioner's application that has been pending. I say that, my Lord, because it not only works for the LSK, Mr. President, it also works for the first respondent who has been required by this Honorable Court to give an explanation. And that explanation will have the purpose and effect of answering the application dated 22nd August 2024 by the Law Society of Kenya. In terms of final directions, we would pray that on our application we serve our written submissions by end of day tomorrow, by Monday. We do have them in draft form, but we could file and serve Monday. Or we be close of business today, because they are ready. Today for hearing on Monday. Sorry? Today for hearing on Monday. Today. We file our written submissions on the application and serve by close of business today. And with the permission of the court, we take directions on the LSK application so we can respond to both applications. Then maybe I join my learned senior, Miller, on a priority hearing disease within the 7-day window. Thank you.
Yes, my Lord, I support what you're saying because there are two pending applications, my Lord. I'm praying for the court to give directions on those two pending applications. Because, my Lord, you realize that the sentencing does not bring a closure to the petition. And in terms of priority, my Lord, I believe the applications by the first respondent, owing to its nature, should be given priority in terms of the directions to your petition. Yes, my Lord, and I also wish to be on record, my Lord. I'm kindly requesting the court to be on record that I sought to bring to the attention of the court that there is a constitutional requirement for a party to mitigate before sentencing, as set out by the Supreme Court in the decision of Francis Murwatetu and another versus Republic, EKLR 2017. Thank you, my Lord. Francis Murwatetu and another versus Republic, 2017, EKLR, the Supreme Court. Thank you, my Lord.
Give directions I mean, the only two course would be given sufficient time to apply to it. A day or two will not be good. We could have 7 days before the sufficient time to apply. Lord, give us a mentioned day where we can come.
Give it we ask for 7 days.
My Lord, in addition to that, we are kindly requesting the court, Ms. Omenga, we are kindly requesting the court that our application be heard separately from theirs, my Lord.
My Lord, before the another bite, my name is Ramadan Alibak. There was a prayer that was made on the issue to amend the application, where they attempted to amend the same orally. It is our view that if indeed they intend to amend, perhaps they can serve us with the amended application by close of business today. Then we can put in our response to the same within the said 7 days. So we are opposed to the oral amendment.
All I think we are agreeable. At the very minimum, the court has directed that within 7 days, the first respondent to appear. We will comply. So in between, we can take whatever directions the court wants to fashion. We thought some of those proposals worked for the first petitioner.
So are you able to amend your application?
We are happy to amend by close of business today. We are happy to file our submissions. It's up to us. And we are happy to comply with the court directions. Whichever direction the court gives in respect to the LSK application, they want to delay it, that's up to them.
The LSK application is different than the others.
Yes, my Lord.
My Lord, permit me to seek leave other person. You're possible.
23rd of August 2024, my Lord.
And the one
12.
My Lord, I apologize. Our application is dated 22nd, not 23rd, 22nd.
Na mtazamaji, na baada ya kufuatilia kwa karibu, sasa hivi Jaji Lawrence Mugambi ametoa hukumu yake na kuhukumu kaimu Inspector